As Ashley mentioned, I'm one of the attorneys at Martin and Gifford. There are three of us. Just a little bit of background about myself. I'm a Yankee originally, but I had the good sense to come to Chapel Hill for law school back in, started in 1977, graduated in 1980. So I've been practicing law for a long time. Spent 16 years after law school in Chicago, and then came back to North Carolina in 1996. Both of my daughters went to school in Chapel Hill. My mother moved from New York to Chapel Hill. So I've spent a lot of time in your neck of the woods, and I love it. Will Martin and I started our firm in 2005. Will had already been representing the Association of Realtors for about 8 or 9 years. And since then, we've been general counsel for the association. One of the things that we do is we handle a legal hotline. I encourage anybody who hasn't used it and who has questions to use it. The best way to contact us, it's part of your membership. There's no cost. And if you've got questions, it's always going to be answered by one of us. All of us are lawyers. That's a little bit of an advantage over the folks at the Real Estate Commission. You know, those guys are very experienced over there. They'll answer questions, but they're not all attorneys. The best way to reach us, you can email us at legalhotline@ncrealtors.org, or you can call the Realtor phone number in Greensboro, which is 336-294-1415. So much for the introduction. I'm going to be talking about the changes to the residential forms that were made effective July 1. I am going to talk about one form that was actually changed May 1, and that was the listing agreement. So there were no changes to the listing agreement made on July 1. They were all made on May 1. It had to do with this MLS clear cooperation policy. And I'll talk about that in a little bit. If you're inclined to take notes, don't. I'm going to, in a second, share my screen and show you how to get to a summary of these forms changes that's available on the NC Realtors website. And almost everything that I'm going to talk about is in this summary. And so rather than take notes, you can access it there. So let me go ahead and share my screen and see how this works. I'll try it this way. Let's see. My technology skills. Okay, here we go. So in order to do this, you've got to log in you go to ncrealtors.org is the website. You get a login screen. You're going to need to know your NERDS number. There's mine. And then you type in your password. And once you do that, well, I think it's because I've already logged in. Once you do that, you're going to be able to go to this. There'll be all these icons up in the upper right-hand corner. And if you click on the one, for Q&A, let's see if this works. Please work. Yes, it did. And then scroll down, and here are all the Q&As that we write. We write one of these every week, and these are, you can find them here and search for them. But go to the menu for forms, and then you click on the link for summary of forms changes. And here are all the summaries that have been done over the last few years. There you can see there are several of them. Here's one from May of 2020. And then for July of 2020, there are 3 of them. One's for commercial forms, one's for property management forms. But today we're going to talk about the residential forms. So if you click on that link, and open, you get to this. And it's a summary of all the changes. And here's what's crazy is this year, the changes, there were 12 jointly approved forms that were changed, and a total of 36 forms that were changed or are new, if you include the NC Realtors forms as well. I'm not going to talk about 36 forms. I'm going to focus today on 7 forms that were changed, and then I'm also going to talk about 3 new forms. So I'll just jump right into it. I mean, the most and by the way, one thing that's great about this document is if you click on these links in here, you get a highlighted version of the form showing all the changes in yellow. And so the easiest way for me to go through this is just to kind of scroll through and show you where the changes are. So I don't know why actually the top here, consult guidelines, is in yellow. There's no change there. But so the first change is in paragraph 1F. This is pretty irrelevant change for realtors. It's a change that was really added for at the request of lawyers. It basically says that the escrow agent, which is often a lawyer, is authorized, or there's a consent that the escrow agent can disclose material facts about an earnest money deposit. You know, the question came up: what if the earnest money deposit bounces? Could lawyers tell the parties that the earnest money deposit bounced? They thought that might be confidential information. So now there's clear consent to that. There's no problem with a lawyer disclosing that. Another change, right below paragraph 1L, where they define what the settlement date is, there's a new note. And the note references the fact that in paragraph 12, there's a delay in settlement provision in the contract. And why is this here? I mean, I think the reason it's here is to kind of alert people, you know, that the settlement date isn't always written in stone. You know, sellers who plan to, or I don't know, maybe buyers who plan to move in on the settlement date, they ought to know that it's possible that the settlement date may shift by as much as 14 days. And so it's just kind of an alert to people. Okay, one of the more significant changes has to do with paragraph 2, which is the fixtures paragraph. Something that's new is this warning here in this box in the form. And what it says is that the parties should not assume that anything that they see in the house will or will not be included in the sale based on some kind of oral or written statement. So for example, you know, this comes up on the hotline. We hear from people that, well, it was in the MLS listing that there was a refrigerator. Well, you know, refrigerators are typically not a fixture. That's an appliance it's not built in usually. And so it can be removed. So what this is saying is a warning that just because it's been mentioned by someone doesn't mean it's part of the contract. Make sure you look at the contract to see what's included and what's not included. Paragraph A and B are highlighted here. There's some wording that was in the old A. It's kind of been separated out into a separate paragraph. But the language really is not too new. There's some more capital letters than there used to be, but other than that, it's not that new. One thing that is new is this language here at the bottom of B. All items listed include both traditional and smart versions and any exclusively dedicated or related equipment and or remote control devices. So smart, you know, I'm not sure what this might include. Smart doorbells, you know, remote controls, I think, are a big part of it. If there are smart devices that have a remote control, those are included. But not all smart devices are included. So for example, if you have an Alexa in your house, that might be a smart device, but it's not a fixture, and it's not something that's exclusively dedicated to some other type of fixture in the house. Your Alexa can be used for all kinds of things. So that doesn't make it a fixture just because it's smart. But that is a big change. Another change, we've added the word thermostats. Hard to imagine to me that people were taking their thermostats with them, but now it's clear that that a thermostat is a fixture and it stays in the house. Another change, this whole note here in the section regarding fuel tanks, this was added at the request of the North Carolina Propane Gas Association. and it says state law provides that it is unlawful for any person other than the supplier or the owner of a fuel supply tank to disconnect, interrupt, or fill the supply tank with either LP gas or propane gas without the consent of the supplier. So it's just a reminder to people not to drain these tanks or disconnect these tanks unless you're the owner of the tank or the supplier of that tank. Paragraph 3 is the personal property section where if the buyer wants to purchase some personal property that is not a fixture, this is where it needs to be listed. And the note here is just sort of stresses the importance of identifying any personal property that's going to be included as part of the sale. I mean, it's always been important, but now it's just highlighting, stressing it. A very minor change in paragraph 9. Paragraph 9 deals with prorations. And it used to say, unless otherwise provided, the other items are prorated. And there's sometimes questions come up about the weird way that real property is prorated. Real property is taxed. The tax bills come out in January, but the taxes are paid July 1 through June 30. And that's the way it's historically always been done. But the parties can agree to prorate things like taxes and rents on some other basis other than the way it's set forth in the contract. And so paragraph 9 now makes that clear. Paragraph 13, this stuff in yellow, there really is no change in paragraph 13, so you can ignore that. Paragraph 20, this is something that's sort of significant. Paragraph 20 has always provided, or has recently provided, that the parties can conduct their transaction electronically by means of emails and DocuSign and those kinds of programs. But a question has come up about, well, if you deliver something electronically, how do you know if it's delivered on time? And maybe the time that this comes up the most frequently, it seems to me, is terminations. Parties are arguing about due diligence, and the seller is dragging their feet, and the buyer is concerned that they don't have an agreement, and they're hoping to get an agreement, but they wait till the very last minute before they say, okay, well, look, if you're not going to agree to what I want, I'm terminating. And the buyer agent sends the termination form at 4:59 in the afternoon, and the listing agent says, well, my email system says it didn't arrive till 5:01, so it's not timely. And so they get into a dispute about, well, when is the notice of termination deemed delivered? And this language is now clarifies that it's basically deemed delivered when sent. But not only when it's sent, but when it's properly sent. So when it's sent in a form capable of being processed by the receiving party's system. So, I mean, if you're sending an email, it's a standard email, essentially it's going to be considered delivered when sent. So that's kind of an important change. And a sort of a related question that's come up, and in fact, I'll give you a little preview of a Q&A that's going to come out this coming Monday. Some people ask about, well, all right, what if somebody's in a different time zone? So what if somebody, let's say the seller is in California, and or maybe let's say let's say somebody's in California, or they're in Europe or somewhere else. And the question is, well, which time zone applies for when you deliver a document? And this is actually covered. I think it's in a different paragraph here, but it's always North Carolina time that applies. And here it is. It's in paragraph 22. Any reference to a date or time shall refer to the date or time in North Carolina. So it doesn't matter if let's say somebody sends a termination from California and it's 3 o'clock in the afternoon in California. Well, if it's 6 o'clock at night in North Carolina and it's late, it's late. It doesn't matter if it was on time in the place where the party was. All right, so those are the changes to the offer to purchase. So I'm not going to talk about some of these other changes. You know, there are changes to the guidelines for completing the offer to purchase. I don't know how many people use these guidelines, but those are very helpful to answer questions. Form 2G. The vacant land contract 12T has changes that are very similar to the ones I just went over on Form 2T. I'm not going to go over them again. The guidelines for Form 12T were updated as well. The backup contract addendum. This change in paragraph 8 is not really a substantive change. It's more of a formatting change or a change for purposes of emphasis or a clarification. So if you've got a backup contract and there's a primary contract, when does your contract become primary? Paragraph 8 makes it clear that it only becomes primary if the seller provides the buyer with two things, not just one. Number one, they have to provide written notice that the contract has become primary, but they also have to provide evidence that the primary contract has been terminated. And what kind of evidence are they supposed to provide? That's up here in paragraph 2. Termination of the primary contract shall be evidenced by, and there are 4 things: written notice of a written release signed by the parties, written notice of termination, et cetera, et cetera. So paragraph 8 just makes it clear that there are 2 things that have to be provided. And the definition is important because that notice of primary status triggers a couple of things. Number one, it triggers the obligation of the new buyer to pay their due diligence fee. And here is a change in this form. Paragraph 9, it used to be that the due diligence fee didn't have to be paid for 5 days. Well, now paragraph 9A says it's considered due once the buyer receives notice of primary status, and that payment has to be delivered within 2 days now, not 5 days. The other reason this notice of primary status is important is that the buyer, the backup buyer, has the right to terminate the backup contract up until the time they receive notice of primary status. So once they receive it, they no longer have the right to terminate. They're under contract. It's a valid and binding contract, and so that's an important change. All right, let me go back again. Seller financing addendum, Form 2A5T. I don't think that's a form that's used very often. I don't think seller financing is provided very often. The only change in that form is there's a new warning added in there saying that there are federal and state laws and regulations that limit the ability of people to finance if they're not licensed as lenders. And basically it limits the number of transactions that can be involved. So this is just a new warning. The lead-based paint addendum has a change in this acknowledgement section. I think this is really the result of calls to our hotline. The old language in paragraph, well, first of all, seller has to make some disclosures in this section. They have to either say that they know of some lead-based paint issues or that they have no knowledge. And in 2B, they have to either provide available reports or say that they have no reports. Buyer acknowledgement section used to say that buyer has received copies of all information listed above. And oftentimes there really wasn't much information listed above. And so they were acknowledging receipt of something that they never received. And so C has been revised to now read, buyer acknowledges receipt of seller's statement set forth above and copies of all records listed in B above, if any. So it's not a substantive change, but it's just better language and it still corresponds to the requirements of the federal statute that mandate the use of this form. All righty, let's go back. Another form that's got a significant change, the additional provisions addendum, is used, I think, most frequently maybe when there's rental, when there are tenants, or when a buyer knows right up front that there are issues with the house that they want the seller to deal with. They don't have to wait till Form 310. They want to know right up front that the seller is going to agree to do some repairs. But the change here is paragraph 6, and it has to do with, and I mean, maybe this doesn't come up a lot, but it comes up often enough that we've added this. It has to do with when there's a pool on the property, and oftentimes buyers are looking at property when the pool is not filled. It might be in the winter, it's off season, and in order to see if the pool is operable, if all the equipment is operable, filtration systems are working, that kind of thing. A lot of work has to be done to get the pool ready to even be inspected. And under our Form 2T, it's sort of a little bit unclear whose responsibility it is. In paragraph 4 of Form 2T, the due diligence paragraph, essentially it looks like it's the buyer's responsibility to pay for the costs of all inspections. But in paragraph 8 of Form 2T, it says the seller has the obligation to provide access, including utilities, and turning on utilities for providing access might mean uncovering a pool. Providing utilities might be turning on electricity to a pool. So it wasn't really clear. And so this paragraph was added, and it says, and it basically gives the parties the choice. Who's going to be responsible for the costs associated with allowing an inspection of the pool? Is it the responsibility of the seller or the buyer? Check a box. And if you don't check a box, the buyer's responsible. That is, if you, so I would suggest you add this form if you've got a situation where there's a pool. So that's an important change. Some other forms I'm not going to talk about, some changes. Of additional signature change, you can see it's formatting changes only. Guidelines are formatting changes. The new construction contract Form 800T has some changes that very much are similar to the changes we talked about with Form 2T. And the same thing with the guidelines for the new construction contract. So the next thing is the listing agreement. Obviously an important change. And this is one of the changes that was revised May 1, not changed on July 1. Here's a change that's actually been made on a few of the forms. I think it's a good change. When does it terminate? And it always used to say it terminated at midnight on a certain day. And I don't know, I never know, does midnight mean, is midnight the beginning of the day or the end of the day? I suppose that, that could be confusing. So they've changed midnight to mean 11:59 p.m. It's definitely the end of the day, whatever date you fill in. Like I said, that change has been made on a few other forms as well. So again, this is a new note in the listing agreement, an agreement that a listing agent is going to go over with their client when they take a listing. And this note is referring to paragraphs 3 and 4 of the listing agreement. Paragraph 3 is identical. These two paragraphs are identical to the fixtures paragraph of the Form 2T and the personal property paragraph of Form 2T. And what this note says is these two paragraphs that appear below are part of Form 2T, and it's Form 2T is a form that's commonly used to put properties under contract. And so it's what what this warning or this note says is, let's go through right now when we're listing the property, what property is there, what is considered fixtures, what are not fixtures, what is there any property that's on your property that you don't own? And one of the most obvious is fuel tanks. A lot of times there are propane tanks that are not owned by the property owner. There could be other things. I mean, I can't imagine what they might be, sheds, something. There could be other things that are there that are not owned and that the owner clearly intends to take with them. Things that are personal property that they might be willing to sell. All these are things. And so this is just, the idea is to have a discussion between a listing agent and an owner at the time a listing is taken. The other yellow that's here, these are the same changes that are in Form 2T. Let's see, next change, paragraph 9. So paragraph 9, you can see there's a lot of yellow here, and paragraph 9 looks a lot different than the old paragraph 9, which also talked about the firm's duties. But honestly, the changes are mostly formatting. They're not, with one exception, they're mostly formatting. Instead of being, the old form had 3 paragraphs, and then it was followed up by this non-discrimination language down at the bottom. The new form, the new paragraph 9 has this note box, and now it has 5 separate paragraphs. And the note, this language has about the code of ethics, talks about dealing with multiple offers. It was in the old form, it's still there, but now it's, I suppose, highlighted. And the rest of these duties were all in the old form, but they're just kind of broken out to say, you know, here are the duties that we've got to you. And I think one of the most significant change here is this initials at the bottom of paragraph 9, where the seller will acknowledge that they've been made aware of each of those duties set forth above. So when you're filling out a listing agreement, that's important. Just in passing, I'll point out that this non-discrimination language is also a language that was changed in several forms, and this was done at the request of the North Carolina Real Estate Commission. You know, this language is in these forms because it's required by a rule, a North Carolina Real Estate Commission rule, except that our language didn't exactly track the language of the rules. So we've now taken out these words, especially in the first sentence, to track the exact language of the statute or the rule. And the second sentence of this non-discrimination language talks about the fact that under the code of ethics, realtors actually have greater duties than are required by law. Realtors are not allowed to discriminate on the basis of either sexual orientation or gender identity. And so that sentence tracks, sort of adds on to the other non-discrimination language. All right, paragraph 10 is the major change to the listing agreement. And again, this was done effective on May 1. Why May 1? Well, and maybe everybody knows about this by now, but in case anybody doesn't, the National Association of Realtors Board of Directors decided last fall to roll out a new policy known as the Clear Cooperation Policy. And they mandated that all realtor MLSs implement that policy by May 1. And what is the policy? The policy basically says that within 1 day of a realtor marketing a property to the public, the listing broker must submit the listing to the MLS for cooperation with other participants. Why did the board of directors do that? They were concerned about what they saw as a proliferation of off MLS listings. They felt that that was a practice that was not in the best interest of consumers. They feel strongly that the MLS provides the broadest possible exposure for property, and that that realtors, if they're going to market the property to the public, you know, let's say on the internet or on signs or any other way, if it's marketed to the public, it's got to be in the MLS. It can be coming soon if your local board allows coming soon. And the only exception to that is if you're using an office exclusive listing. And office exclusive listings are still permitted. But with that essential change, I mean, otherwise, paragraph 10, again, it's reordered in a lot of ways. A lot of language was moved around. But other than that, paragraph 10 hasn't changed that much. But one of the things that's done is this submission to a listing service was put right up front. And it says that the firm shall submit information concerning the property to any listing service of which the firm is a member, in accordance with the rules of any such listing service. And that means now, within a day. And so that's the main thing. It's put right up front. Paragraph 10b talks about when a firm can market the property, and it doesn't have to be when the listing agreement is effective. It can be a delayed marketing date, but this language is put in. This was always in the form, but it says if a delayed marketing date is elected or selected, that there could be some limits on what kind of marketing can take place until that delayed marketing date, such as no showings. And there can't be any public marketing, internet marketing, except as may be permitted under coming soon. So, these were changes that, again, were authorized by or required by the National Association of Realtors. Paragraph C, this is the marketing authorization. These were things that were always, with the exception of this coming soon, these were things that were always in the old form. This laundry list or menu of marketing things that can be authorized. Coming soon marketing is added. The lockbox thing was taken out of 10C. Why? Because if a seller elects this office exclusive, then they're not allowed to do any of this public marketing that's in 10C. None of it. But they are still allowed to do lockboxes, and that's why you can still have a lockbox, and that's separated out into 10D. Hope that makes sense. 10C is basically all public marketing. 10D is not. It can be used either in public or in office exclusive. And so they'd still have this, where is it? This note here in paragraph 10, telling sellers, we think it's in the best interest to get the highest possible price to expose it to the widest group of potential buyers, sort of discouraging sellers from office exclusive listings. So, the essential change in paragraph 10 is you got to comply with the clear cooperation policy, have to submit all listings to the MLS within 1 day of any public marketing. And by the way, public marketing is defined in paragraph 10b. Public marketing includes, but not limited to, flyers and windows, yard signs, digital marketing on public-facing websites, et cetera, et cetera. So once there's public marketing, that triggers the obligation put in the MLS. Those are all the changes to paragraph 10, to the listing agreement. Going back to this laundry list here. Trying to stay within my time frame. Guidelines, these were updated. I'm not going to go over that. Form 103, vacant land listing agreement, similar changes to Form 101. Those were also a May 1 release. The guidelines were updated. The internet advertising addendum, this was another one that was effective May 1. Let's see. The Form 150 is the unrepresented seller disclosure and fee agreement form. This is what we commonly refer to as the FSBO form. The only minor change to that was to the non-discrimination language that I talked about earlier, where they took out a few words to make it consistent with the Real Estate Commission rule. Buyer agency agreement, a couple of changes to that. Really paragraph 3 is the only change of significance. Basically the change here is we've added a couple of check boxes. Buyer agency, I think typically is for buyers that only want to buy one property. But what about buyers that are interested in purchasing or may be interested in purchasing more than one property? The issue came up, well, does the buyer agency agreement, it used to say it would terminate when the buyer acquires real property. Well, you don't want it to terminate, so now we've got two options. You check a box here for buyers who intend to purchase a single property, it terminates either when they purchase the property or no longer at midnight at 11:59 on a specific date. For buyers who may purchase more than one property, it terminates on a specific date. So that's really the only change to that form.
Bill?
Yeah.
We have a question. It says, please explain one day as it relates to weekends.
Not sure the context of that question. One day. So I think maybe that's talking about one in Form 2T. I'm gonna guess it relates to. Let me just take a guess here.
Yes, is what I think he means the one day for getting it into the MLS from.
Okay. Good question. I would think it would be one business day. I don't know if I'm not a realtor, and so I've never submitted a listing to the MLS. Good question. I'm gonna say it's one business day. Give me a second. That's a good question. I might be able to. I'd like to be able to answer that categorically. The Clear Cooperation Day policy says one business day. So not weekends, not holidays. I don't know that that's so clear in Form 101. Let me see if Form 101 says that. But the Clear Cooperation policy requires it in one business day. Yeah, actually the form paragraph 10 only says it has to comply with the rules. It doesn't say when, but the Clear Cooperation policy is one business day. So that's a good question. All right, where am I? So guidelines for Form 201, some minor changes, the same with non-exclusive buyer agency, Form 203, similar changes to 201, not worth going into. Form 220, just some formatting changes, the guidelines, again, formatting changes. Form 310, a very commonly used form, but really wasn't changed this year except for formatting. Okay, now we get down to some new forms, and you can see there are no links to these, but these forms are available on the website. So let me see if I can get to that form. Can you see that, Ashley?
Yes, I can.
Okay, good. So Form 360 is a new form, and what it is a worksheet. And I'm going to presume that this is something that agents is a good idea. What this does is it basically puts on essentially one page, a little over one page, everything that's in a blank on the offer to purchase. Seller name, buyer name, purchase price, due diligence fee, everything. And it's kind of a, maybe an easy place to look for all of the information that ends up getting into a contract. It says here that it summarizes the terms. It's designed for use by a buyer or seller and their agent as an internal reference tool. And then, boy, in capital letters, and this needs to be emphasized, this is not a contract. It's not part of the contract. It shouldn't be used to create a contract. It doesn't have any signature lines. It's not a substitute for a contract. So please don't use it for that. But it is, it is something that may be helpful for agents. So I got to find the rest of my stuff here. Okay, Form 360. Form 710 has minor changes. Termination of agency agreement has minor changes. They just added to the laundry list of forms or agreements that can be terminated. Again, here's another new form, a broker to builder referral agreement. And this is a form, I would say we've gotten a lot of demand for this. This is the wrong form. Wait a minute, maybe I skipped over something. Let me go back here. Oh, I did. Let me go back. This is another new form, exclusive tenant representation agreement. There are plenty of agents out there, I think, who are being asked by tenants to help them find a place to live. And we really didn't have, for the residential context, a tenant representation agreement. And if you were going to act as an agent for a tenant, the Real Estate Commission rules require that you have an agency agreement. And so what we used to have to tell people is, well, there's a commercial form, and you can use that and modify it. I think the reason there was a reluctance to create a form like this is property managers, I think, were somehow requesting that we not have a form like this, but now we've got it. It is, it's a form that's basically very similar to the buyer agency agreement. And I mean, it's got a provision for dual agency, which may happen if you've got a tenant that's looking at a property that you have under management. So it's got everything I think you need if you want to represent a tenant. It's a form that we haven't ever had before for whatever reason. So that's Form 460.
Real quick, I've got a question here for a little further clarification on the one-day thing for the MLS.
Yep.
Do you think that means marketing can begin on Friday and the listing not go in the MLS until Monday?
I mean, the policy says, it does say one business day. I think that they, the idea is to expose properties to the market. I mean, I'm not sure what listing agents might be trying to accomplish, marketing it on Friday. But they have one business day. I mean, so yeah, if they want to try to, if they think there's an advantage to public marketing it on Monday and putting it in the MLS, on Friday and putting it in the MLS on Monday, they will not be violating the letter of the clear cooperation policy. They won't be doing anything wrong. Okay, Ashley?
So Okay, I think another agent answered the question.
What's that?
Got it. That's it. We got it.
Okay. Okay. Almost finished here. I'm going to try to get us in under the wire here with an hour. Okay, another new form, Form 731, is this broker to builder referral form. Again, I think we've gotten a lot of demand for a form like this. Situation where a buyer agent basically puts a buyer in touch with a builder, and the builder offers compensation. I think this is really common. We really didn't have an agreement for this, and there are really two options here. Sometimes the builder, the buyer is buying property from someone other than the builder, or the other option is the buyer is buying property from the builder and having vacant land that the builder owns and building on it. And the compensation, there are two compensation sections. The first is compensation based on the cost of improvements, and then on this page, compensation based on the cost of the real property and improvements. There is a place for the prospect, the buyer, to acknowledge being made aware of that. That's in order to comply with the Real Estate Commission rule that says if you're being compensated in connection with a transaction, that needs to be disclosed. And so this is not an agency agreement. It's merely a referral agreement. Let's see if there's anything else I need to tell you about that. I mean, if you've got questions, I guess give us a call. But I think it's something that there's been a lot of call for, and I think it's will be very helpful to agents. All right, what else? Form 760. This is a professional services disclosure and election form. I think, I don't know if all buyer agents use this form. I strongly recommend the use of this form. I've been involved in representing a lot of agents in litigation where this form would have been a big help. And there's been a couple of changes to it. Some of them are formatting, some of them are not. This language in paragraph 1 has been added. With respect to each service selected, indicate who will order the service, the name of the service provider. With respect to each service selected, indicate who will order the service and the name of the service provider selected by the buyer or seller. So what agents should do, and this is typically buyer agents, but I suppose it can happen with listing agents as well, is they should go down this list and on each line either check the box for waived or selected. And then if it is selected, make a decision who's going to take care of ordering this service. Is it going to be the agent or is it going to be the buyer? And then fill in the name of the service provider. The services, most of these have been in the form before. They've been reordered. All the inspections are now in a list. They were sort of spread out before. I think there's a new one. I think pool and spa is new. Also, another thing that's new is this re-inspections. Sometimes re-inspections are important, and who's going to arrange for re-inspections of repairs. And then another change to this form is a suggestion that with respect to radon and other environmental issues, basically it's saying brokers are not experts in knowing whether this kind of testing should be done. And it's recommending that buyer or seller should consult with an air or water quality specialist regarding the need for that kind of testing. And it's suggesting that consideration be given to radon testing and air and any private water, drinking water testing. We've always had a similar note regarding surveys, the importance of getting a survey, but this is kind of stressing the importance of getting other kinds of environmental quality testing well water is an issue that's come up. And that's really it. I think I got in just under an hour. Those are the major changes, the significant changes to the forms, and those are the new forms.
Bill, I have a question in the chat.
Okay.
There's a great deal of frustration over the use of forms. With so many, we find it difficult to search what we need. Any suggestions as to where to look for a form that makes it easier to find? It is difficult to remember the title or numbers of the forms.
You know, I hear your pain. Whoever asked that question, I will make a suggestion to the folks at NCAR. There is a cheat sheet out there that I have them send me every year with a list of forms, and I refer to it all the time. And I'm not sure why it's not out there available to members, but I will see what I can do about making it available. I think that's a good suggestion. But no, there is no. I'm not aware of any list that's out there now. But if you can't find something, call the hotline or email us.
You want to give?
And of course, these summary of forms changes have a pretty extensive list of forms, but it's not complete for sure.
Do you mind giving me the legal hotline email one more time, and I'll put it in the chat?
It's legalhotline@ncrealtors.org. Wow. 27 people. I didn't know there were so many people watching.
And I don't think that is last call for any questions. Does anybody have any further questions?
Yeah, I appreciate y'all taking the time to listen to this. Hopefully it's been helpful. Like I say, that cheat sheet that's available by going to the homepage, going to Q&A, forms, and then summary of forms changes, we'll really go over a lot of this, exactly what I went over today. And the highlighted versions are all available by clicking on the links. So I think that would be helpful.
One more question. Has there ever been any discussion of updating the forms in January instead? July is a pretty busy time for us to be learning new forms.
I don't know. I'll ask. You know, I know that I've been representing the realtors since 2005, and it's always been done that way. But just because it's always done that way doesn't mean it has to be. Let me just comment on one other thing. I think it was Latanya was asking a question before we got started about the contingent sale addendum and not having one. You know, we did get rid of that. That was not a change this year. It goes back either a year ago or maybe 2 years ago now. You know, the thought is that the fact that a buyer needs to sell property is just one of the many things, like the buyer's ability to get a loan, that the buyer needs to get under control during the due diligence period. And so it's not a contingency anymore, but it is, you know, the buyer still has the right to get out of a contract if they don't feel comfortable about their ability to sell their property during the due diligence period. And so what they need to do, you know, if buyers have a place they need to sell, what they need to negotiate for is as long a due diligence period as possible so they can try to get that under control. If they really want to make their offer contingent, we no longer have a form. The use of our old form is not something that's permitted by our forms policy. But lawyers can draft one. And obviously I think that makes their offer a little bit less attractive to sellers, but it is, we no longer have the form. It added a lot of confusion. We didn't think it was really a materially different thing than all of the other issues that buyers have to deal with during the due diligence period, like the ability to get a loan, like negotiating repairs. everything else. So hopefully that helps with Tanya.
Thanks.
Okay.
Thank you.
You're welcome.
So one question though, is there customarily a time frame? I mean, because normally due diligence is fairly short, less than 30 days. So is there a time limit that you can put on due diligence?
No, I mean, that's the thing about due diligence period and due diligence fee. It's entirely negotiable. I mean, in a way, the due diligence period is like an option, and what you're paying for is the option to get out of the contract completely. And so I think if you're willing to give a seller enough money, they'll give you a lot of time. It's just a question of negotiation. So.
Okay.
I'm seeing something in the chat room. Only protect earnest money. So.
All right. Well, thank you all for coming. Thank you, Bill, for doing this for us today. We really appreciate it.
You're welcome.
Definitely a good thing to educate the agents that are out here using these forms every day. So thank you very much.
All right. Well, you're welcome, and feel free to use the hotline anytime. Take care, everybody.
All right. Bye, everybody. Have a great day.